Hello, my name is Peter Bricks. I'm a debtor bankruptcy attorney in Atlanta, Georgia. I have offices in Dunwoody, Jonesboro, and Cumming. Um, Today I'm going to talk to you about garnishments in bankruptcy, how bankruptcy stops them, and additionally how you can potentially recapture garnished funds. But first I want to start with this disclaimer. We are a debt relief agency proudly assisting consumers in filing bankruptcy. There is no attorney-client relationship with the viewer of this message unless there is a fee agreement. We would have to meet with you individually to offer you applicable and accurate legal advice. This video is intended for informational purposes only. Okay, so today we're discussing garnishments in bankruptcy. First question is, are garnishments going to stop when you file bankruptcy? Answer to that is yes. There could be a real limited circumstance where you are what's called a serial filer, and you don't have the protection of the automatic stay, but let's exclude that. That's probably pretty rare. Let's assume you have the automatic stay. Will bankruptcy stop your garnishment? Yes. That's true whether you're going into Chapter 7, Chapter 13 bankruptcy. That's by virtue of the automatic stay. So what I generally do when clients being garnished, a lot of times that's what's leading them to file. Your garnishment laws will vary by state. In Georgia, you're going to lose approximately 25% of your take-home pay, assuming the garnishment's on your paycheck. What I'll normally do is contact ahead of time, have the client give me their HR's information. As soon as the case is filed, we send a notice of garnishment, notice of the stay to the HR department and tell them to immediately stop the garnishment. If the HR department's on the ball, they'll be able to process that and get the garnishment stopped before the next check. Now, the question, simple enough, garnishment over. Now the next question is garnished funds that have been garnished. Where are they? They really can be in one of three places. When the funds are garnished, they could be in your HR department's hands. That's number one. Number two is the HR department could have turned them over to the state court that's authorized the garnishment. And number three is the creditor could have already recouped them from the state court. That'll depend how far along you are in the process. So why is that relevant? Well, the reason that's relevant is a debtor actually can potentially recover garnished funds. There is a code section that allows debtors to recover, or rather that lets the bankruptcy estate recover garnished funds. It's 11 U.S.C. 547. Funds involuntarily taken from the debtor in the 90 days preceding the filing can be set aside as a preference. So now we're left with the specifics of, and the funds have to be over $600. So we're left with the specifics. Is it greater than $600? And it wasn't the 90 days before filing. So that's going to be fact specific. The only thing I can say is if it's less than 600, not that the debtor can't get it, but that'll depend on state law issues. When does it would essentially be a state law question of who owns the property. Was it still the debtor's property when the HR took it? Was it still the debtor's property when the HR paid it into court? Or was it the creditor's property the second the HR took it? That kind of thing. So let's keep it as far as bankruptcy is concerned. Federal law, over $600 in the last 90 days. Debtors get what are called exemptions in bankruptcy. So this exemption would pretty much come down to, presumably it'd be under the debtor's wild card. And the question is, does the debtor have enough funds? If, say, the debtor lost $1,000 in the 90 days before filing, does the debtor have enough of an exemption? And this is really a Chapter 7 situation. That 13 gets a little more complicated. Does the debtor have enough wild card where the debtor can exempt the recoupment of the funds, or does the debtor not even have enough exemption to protect it, and therefore the trustee is the one who gets to recoup the funds? That's the question. So that'll be another fact-specific thing. So assuming the debtor can recoup the funds, the debtor under 11 USC 522H can recover the funds if the debtor's exemptions support that. So, believe it or not, a creditor who validly got a judgment, validly started a garnishment, and validly took funds can actually have to return those funds if the debtor were to file bankruptcy in the 90-day window uh, subsequent to that. So it might sound unusual that you could have a backward-looking thing there, but that's actually the case. So that pretty much covers garnishment and Chapter 7 bankruptcy.